Today we want to talk about 10 things, 5 things you should deal with, and 5 things you should better avoid in the early stage. Let's have it like an open lecture, so whenever something is unclear, raise a hand or shoot out a question to me. That's fine. So Mathieu did a little put your hands up. I want to continue with that. So who of you has already founded a company? Okay, only a few. What entity did you take? A GmbH? UG? Okay. What else? French? Hong Kong? So limited. Okay. Did you encounter any problems while founding? Like for the UG? Fairly simple. Say again? Okay, so you encountered in the end problems with the shareholders, but not during foundation. You had to shut down. Okay, the question is whether the lecture today is about founding and tips and tricks about the early stage process in Germany or in France. As I'm a German lawyer, I'm only really qualified to talk about German law, so it will be about German law, and in particular, like mainly about setting up a GmbH and what you encounter with concluding contracts with employees, with customers, and what else you should avoid or take care of. The question was whether it is different in Spain, France, UK. From the foundation, there are legal formalities in each country you have to adhere to. Like it's a little different. It is a lot easier to set up a UK limited, probably, because you don't have to use a notary and stuff. But like the other remarks I will give regarding concluding contracts and securing of IP rights will more or less apply to every country. Okay, so when you decide about setting up a company, my advice is keep it simple. So you don't have to have any fancy legal entities. So we've seen here, those of you who have already founded went for the UG. The UG is, like I always say, the small sister of the GmbH. So it's just a normal GmbH with, and the GmbH has a share capital of 25,000. A UG, you can start with €1. However, I do not advise to start with €1 because then you can't put any formation costs into the company. And if you encounter any obligations, then you would have to go straight away to the insolvency code and file for insolvency, because you are then already over-indebted. So at least a couple of €100 should be the stated capital, but then you can start off, and this is just like the appropriate form and typical form to start off a new venture. Some companies think the corporation, the Aktiengesellschaft, the AG, is also a good form. I think it's at the very beginning it's too complicated, and it's the costs are different. You have to have 50,000 as a stated capital compared to a GmbH of 25,000 or a UG of even a lot less. And you have as well a tier system, so you have a board of directors and an advisory board. I think if you start off with 2 or 3 founders, or even 1 or 2 more, it doesn't really need an advisory board in the beginning. So my advice is keep it simple. Foreign legal entities, you can use them. That depends really on your business model. If you think like most of your customers and all the business model is, for instance, to hit on the US market, you might want to think about an incorporation there. And if you think like all your investors are typically from the US market, then it might make sense. Or you do like the German company and have a founding entity, like a holding entity on top. With regard to the company name, if you not only already have one in mind, then do a little research on the relevant databases. This is For once the commercial register, you can go on www.handelsregister.de, which is like the German page where all entities are registered, and there you can see whether the same name is already used by another company, because then you might have a conflict and you can't register this company. And at the same time, you should go also on the web page of the Authority for Trademarks and Patents in Germany. That is DPMA. And there you can see if there are any word marks or other trademarks already registered, which are similar to that. You can do your own research. You don't really need a lawyer for that or an external advisor. However, if you want to do it kind of more bulletproof, there are external advisors who have some analytic gears where they play around with the letters, skipping one and adding one, so you can see if there are any similarities between the name you want to use and the names which are already registered. It's not that expensive, so if you really want to make sure that you don't have to change your name afterwards, because after whatever, if you got to market and then someone realizes, oh, there's your company as well, and they approach you and say, okay, you are infringing our IP rights, then you have to rename the whole company, and that's no fun as well. Then if you decide about the seat of the company and you're not already convinced that Berlin is the place to be, at least think about whether the ecosystem is startup friendly, because I've countered some startups who are in the south of Germany, not Munich, because Munich works fine as well, where the registered judges are not so familiar with the financing round and capital increases. So it took at least 2 to 3 times the time for a normal registration of a financing round than it should have been, and as well the creation of approved capital. It was a nightmare to get it through, even though it was just plain simple in Berlin within a couple of days. And there in another city, we took about 3 weeks for that. So this is also a point you should keep in mind. With regard to the corporate purpose or the company purpose, if you are unsure whether it is the right description and whether it is still possible to have this corporate purpose registered, just look what your competitors or likely competitors have registered, because there's some certain probability if it works once, it will work the same for you. And you can also talk to the Chamber of Commerce and Industry in the city, so in Berlin as well, and ask them beforehand whether your intended name and the corporate purpose is okay, because then you don't have to amend it afterwards after notarization, because this would otherwise incur some additional costs. So this is also what you should avoid. And last, for the incorporation purpose as well, to keep in mind opening of the bank account. You always think, okay, you only have to go to the bank and the account is open. This is not always that easy. I have even seen, like, when we founded a subsidiary from a UK limited, it took us about 4 weeks to get the account open, even though they had good relationships with the bank. It's a major bank, but it was quite time consuming. There are some banks who are quite fast, some are a little bit more complicated, but if you have to found quite quickly, you have to keep that in mind and have maybe a plan B with another bank for your bank account.
You wanted to open a UK bank account, but as a German entity? Or?
No, the question was whether it was a UK bank account. No, that's not what I want to say. When you found a GmbH or UG, you need a company account. And the problem is all the know your customer documents the bank needs. So even though the UK Limited, the mother company, had a very good relationship with the bank, it took them nearly 4 weeks to open a bank account for the newly founded subsidiary here in Germany. Because the process is, you go to the notary, notarize the foundation deed, then you have to open a bank account, you pay in the stated capital, or at least if you are for a normal GmbH, you pay in at least half of the stated capital, and once the payment is on the bank account, the contributions, the application to the commercial register can be filed. And therefore, in order to have a company, you need the bank account. Okay? Yeah. The question was whether you have to put in 25,000 into the bank account and whether the company is only fine and set up once it's on the bank account. Yes, like the first step, as I mentioned, is the notarization. Then you are a company in foundation. And with your example, if you get a 25,000 GmbH, you only have to pay in half, so 12.5. Has to pay it in cash. And then once it's on the bank account, the managing director will file this company with a commercial register, and then it will be registered. You will sign the application to the commercial register already at notarization, but the notary will keep it in like an escrow until you have proven to him that the money is on the account, because if you would send it off straight away, it would include a false declaration and there would be a criminal offense. Okay, so the next one, still with the foundation, detailed articles. My recommendation is that you keep it simple here as well. It's not needed to have any sophisticated articles of association at the very beginning, and probably every notary can draft you a proper set of articles. And from my perspective, even though I'm a lawyer as well, you don't need a lawyer at that stage, because you have to pay the notary anyway, because any foundation of a UG or a GmbH requires notarization, so a notary. Therefore, just skip the lawyer's fees on that and go for a simple set of articles, because at the latest, when an investor, a real investor, steps in, it's normally like a set of things. You get the funds, but you already also get at the same time a set of documents, which is the investment or shareholders agreement, normally managing director service agreement, maybe rules of procedure for the management, and as well changed articles. So there's no real advantage to have very sophisticated articles in the very beginning. So just take a very short one, and even bilingual, they don't need to be more than 2 or 3 pages, because the rest is can be taken from the general German corporate law, and in particular, if you're found with 2 or 3 members, you can have even clauses if there is a conflict between you 3 and one has to be kind of kicked out, then there are clauses which are called like Texan or Mexican shootout, which is like a figurative thing, but in the end, you can have those clauses and you can fight them through with a lawyer on each side, but it will be too much cost and too much time. So the only way is to get an agreement, a settlement between the founders if they have to separate before the refinancing starts. And this is my recommendation. And I have encountered a couple of cases where we had to do this and agree on kind of installments when the investor comes in or do secondaries. So that the old founder who doesn't want to be part of the company anymore steps out.
What about vesting then? Is that also this?
The question was whether the articles shall include vesting. At this early point in time, I think it doesn't need to have vesting, because if you have a proper clause in there that any transfer of shares requires the consent of the other shareholders, then you don't actually need a vesting at that point. Vesting is normally requested by investors, and then because you have to decide the articles of association, they are published in the commercial register. So everyone who's paying 150 for the electronic release can have a look at these articles. Therefore, anything else like put or call option, vestings, tag along, drag along, whatever, should be put in a separate agreement, a shareholders or an investment agreement, because this is then normally also notarized, because there are some requirements, formal requirements, but it will not have to be published.
So are there some templates for...
There are a number of different samples, but if you want to found a company, you just go to a notary and say, okay, I want to use the name, the company purpose, we are 3 founders, everyone gets a third, and the stated share capital shall be such and such amount, and he will draft one. And if you can ask him as well whether you want to have it like only in German or bilingual. Not all of them are so confident in English, but there are a lot, at least a few, who do this. So what is your opinion about NDAs? Do you always need an NDA? The problem is investors don't really like to sign NDAs all the time. Some of them even react allergic. So you're stuck between a rock and a hard place because on the one hand side, you're not really willing to disclose too much information about your business. But on the other hand, investors don't like it. So my advice is, if you still tend to sign an NDA, just approach the investor and ask whether it's fine to sign one. If they say, okay, yes, for this instance we do, it's a pleasure for you, we do it. Otherwise, just skip it, because it's part of the game. Sooner or later, you have to go public anyway. So it only extends the period a little bit. Now, coming to contracts. The question here is as well, like for general contracts as well as for, in particular, customer contracts, how should we draft those? And here as well, at least in the very beginning, keep it simple, not too sophisticated, because it takes quite some effort and takes cost. And from a legal perspective, yes, it is important to take care of everything. And as a lawyer, yes, you can do very nice agreements, 20, 30, 40, whatever pages. But the problem is, in the beginning, you're either lacking the funds, or if you have still enough funds, they are probably better to spend on marketing, on product development, on HR. So my recommendation would be start off with a simple agreement, and then over time supplement, amendment whenever necessary to make it then more adapting to your business model.
So do lawyers help?
Here lawyers can definitely help. It depends on which kind of agreement you're looking at, but normally we are not drafting each contract from every word, but we have our sample documents, and then take parts here and there and then draft it to your needs. But there are as well databases, and maybe either Mathieu or Hugo will give you some insight about it, because they are working on something so there's a kind of open database where you can use like standard basic documents which can be used at the very beginning. And the same applies for sure for HR contracts. So use sample contracts and do not customize them too much, at least in the very beginning. And the problem here is sometimes that I'm asked to review some employee agreements, relationship agreements, and these are taken from the internet. It's not a problem to take these from internet, or to ask colleagues and friends, do you have a good employment agreement for this kind of employee? But I experienced quite some time that it is sometimes even more time-consuming than costly to review those contracts instead of drafting them or giving them sample documents from my company. Because with our draft documents, we know they are all in line with legal principles, and with the others we would have to go provision by provision and check whether they are still in line with the principle. And when you start off with a small group of founders, the question is whether you really need a managing director's service contract or not. It's probably the same what I mentioned before. So when an investor steps in, he will have a proper, or he will present you a managing director service agreement, and this is probably the one you then have to use. So these are the 5 things we can skip early stage. So what should we do at the very beginning? You can have an MD service agreement, but you don't need to. So you can be a managing director even without a service agreement. Because the question is, with a service agreement, normally the main part is the remuneration. Because and in the very beginning, until you have good revenues, it's probably hard to pay you a very good remuneration. So in the very beginning, you can take one. You can take just a very plain and simple one, and then normally what I experience that it's part of the set of documents of the investor. No, the question was whether a GmbH can be established without a managing director. No, that is not correct. So you need at least one managing director, but you don't need a managing director service agreement. So that's so you have to distinguish between the function of the managing director and whether you want to have a service agreement for the managing director or not. So, what should we take care of when being early stage? For sure, because it's the main asset for the company, and then as well for the investor, secure your IP rights. So with every employment agreement and agreements with freelancers, take care that there are provisions that any IP rights created in the business are transferred to the company. And if that is impossible, so the transfer is impossible, due to legal reasons, then a license, an unlimited license, is granted to the company. Because otherwise you might have problems at the latest when an investor comes in and he does a short due diligence and mainly as well on the IP rights, and then it's discovered, okay, we had those tech guys and they did the whole coding, but we didn't have any proper agreements, so the rights in the coding are still with the tech guys, and they were freelancers, so there will be a little problem with the investor, because then you have to draft some agreements, and the problem is in particular vibrant if the freelancers are not engaged anymore and you have to run after them, and they will then probably say, okay, yeah, definitely we can transfer these IP rights, but what do I get in return? So take care of them that in the beginning, so you don't have to pay anything in addition later on. So financing, prepare for the financing round. So you are already drafting your pitch decks and you're practicing the presentations for the investors, but at the same time prepare your figures and have your documents ready. So what I mentioned, like the transfer of the IP rights, and as well your main corporate documents should be ready. The question is as well, when you start negotiations with an investor, whether you should sign a term sheet. It's not a must, but it's quite helpful because it's the basis for the drafting of the shareholders agreement, the investment agreement, and even though it's non-binding, it's a kind of gentleman's agreement. So whatever you decided to agree in this term sheet is the basis for the further negotiations, and therefore you should think about it whether it's to be incorporated or not. And in particular, because I had experience with some startups, some problems there, check the numbers, because sometimes you get the term sheet because it's already agreed upon between the startup and the VC, and then you start drafting the investment agreement, do your calculation for the cap table, and present it to the startup, and they suddenly realize, oh, that's not the figures and that's not the percentages we agreed upon. So then you have to take a break, call the VC and see what was the latest status of the negotiation, because the figures in the term sheet did show something different. The next part is probably, yeah, it's a tough one, because saying from a lawyer, do your legal know your legal framework of the business. Yes, it's a complex one, but it might have a huge impact on your company. So whatever regulatory things there are, you should at least keep them in mind. Even if you're disruptive, pay attention to them. And to my mind, like even fintechs, they are not so much regulated by BaFin, which is the German banking authority, supervision authority. But sooner or later, at least some of them will be more and more in the clause. And normal classic banks, they have huge departments just complying with all the requests from BaFin. And if that is at some point in time also the case for at least one or two of the fintechs, it will be as well have a huge impact on your business model, because then you have to put in a lot of more people just to comply with these regulations. So keep it in mind and pay attention to the regulatory framework. Next point is also very important for you if you are the managing director. So social security contributions for employees as well as for freelancers. If you don't pay them, and you should have paid them for employees or freelancers, it's a criminal offense. And the authorities are very likely to go after you. I had a couple of clients who were facing these charges, and that's not funny at all. And the debtor of these social security contributions is always the company. If it's held maybe 1 or 2 years later that you should have paid contributions for 1 or 2 of your employees, then the authorities will go after the company, and you are only able to reclaim, so a claim of recourse to reclaim them from the employee for up to 3 months. So this is also, from a financial point of view, important that you consider whether it's a freelancer, a real freelancer, or not. And if you're in doubt, you can as well inquire with the competent authority that they check and then confirm whether this employmentship under false social security contributions or not. And this point is also important if you want to become again or in another company a managing director, because when founding a company you have to give a declaration that you did not convict any crimes, in particular fraud, and there with a catalog of offenses is also included not paying social security contribution. The same applies if you have if you fail to file for insolvency in due time. So if you encounter financial difficulties and you think, okay, can I still pay all the invoices over the next time? You have to consider to go to the insolvency court, and this should be done immediately at latest, at the very latest within 3 weeks. So these are 2 major things you always have to keep in mind. Pay social security contribution, because it's a personal criminal offense of the managing director, and the same as well, personal criminal offense if belated insolvency filings. Yes, it's more for German ones, and the question is whether you can kind of dictate that he does appear at 9 o'clock, does exactly the job you gave him on the day when you arrived at the office, and he has no other clients or customers. Then this is always hard. This is more a question for the individual case. That you have to decide whether he's still a freelancer or an employee, even though his contract says freelancer, because it doesn't matter what the contract says. It's then what you're living in real life. Yes, last, if you want to already think about it, the ESOPs, so employment stock option programs, you may want to think about whether you want to grant phantom stocks or a direct participation. For both their advantages and disadvantages. For the phantom stocks, to my mind, it's more flexible. You don't have to involve a notary. It is just a contract between those guys being included in the ESOP and the shareholders granting these shares. You are flexible. You can include more people into the ESOP. And on the other side, with the direct participation, there are tax arguments for choosing that direction, because if you go for the ESOP, it's tax by wage tax, and including social security contribution stuff, it might add up to 50%, so being taxed. And with direct participations, meaning that you own shares maybe via a partnership or so, which is on top of the GmbH, it is only taxed by capital gains tax. This is 25% plus, if applicable, church tax and solidarity surcharge. So early stage, if you're just like the 2 or 3 founders of yourself, it doesn't make much of a difference at the beginning. But then if your team grows and you think, okay, I can't pay them really high wages, but let's think about participating them at the future success, you want to think about that. Good. These were the 10 points, and as I mentioned in the very beginnings, some further quick remarks with regard to financing early stage. So at the very beginning, if you're not approaching like a classical VC or corporate VC, and you are still in the seed phase or do a family and friends investment, my recommendation is avoid too small tickets, because it's a lot of work to keep everyone happy, to inform them, to keep them all in line. In particular, if you have to do further financing rounds, all of them have to agree to the capital increase in general, or at least you are trying to have them all agree. And the same applies for private placement, and if not private placements, private investments. It's often subject to multiple changes, so just like a day or two before notarization, even like an hour before notarization, one of your friends said, oh no, I decided otherwise, I don't want to be part of it, and then you're struggling because this is the total amount everyone was supposed to invest, or you wanted to raise a specific amount, then you have to ask someone else, can you jump in and take over his share, and the whole documentation has to be changed. So this is always a little bit more difficult, so it might make sense to limit the number of guys, if that's possible, for sure, of the guys contributing. And if so, if you have quite a few number, then you might want to consider to have a voting pool that only one is kind of spokesman, and the other ones give a power of attorney to this spokesman. So you only have to deal with one person in the next financing rounds, which is at the same time more attractive for the investors, because if they have to deal when they step in with already 15 to 20 other people or entities, it might be a little bit less attractive. Another one, the second point here is the choice of your investor or the investment vehicles. If you have the choice at all, and you can influence it at all, the question is whether you want to pay attention about the legal entity which is investing into your company, because I called it exotic legal forms, like not that exotic, but BVI on the Seychelles, on Cyprus companies. The amount of work to get all the proof of representation and existence is normally a lot higher, and in matters of time and work and costs, compared to like normal European companies, because you have either to get a notarial certificate, which is then apostilled, or you have to gather certificates of incorporation, of incumbency, certificates who are the directors, then get all the documents apostilled, and then afterwards translated by a certified translator into German, because German is still the language the register courts use. Some of them are fine with some English documents, but if you want to try first to hand in the English documents, and then someone says, okay, I can't read them or I can't understand them, then you have to provide them with certified translations. It will take at least an additional 1 or 2 weeks. So if you want to be quick, then prepare the translations straight away. Yeah, these were my remarks for today. So happy to get any further questions you might have. Yeah.
Recommended or not, and what are the pros and cons?
I definitely recommend if you want to found here in Germany to use a UG or GmbH. And the question is between UG and GmbH, how much capital do you want to invest in the beginning? Because GmbH has to be founded with 25,000. That's the minimum share capital. However, only half has to be paid in. With a UG, you can start off with €1, but as already mentioned, I would say let's start with 300, 400, 500 at least. But another thing is a lot of people think that this money has to be kept in the account. You can work with them, you can buy laptops or whatever, you can't consume it, so it can't be vanished. Then you have a problem, and then you have to have certain corporate measures, like another shareholders meeting to declare that half of the stated capital has been gone and stuff like that. But it hasn't. It does not need to be on the bank account for the whole time. And normally, like most startups start off with a UG, and that's fine. It's appropriate. Customers know that startups start off with a UG, and because sometimes there is the saying like, if you are not really confident in your idea and you are not even willing to contribute yourself 12,500, then why should we invest, or why should we conclude a contract with your company? This is sometimes an argument which is raised, but it depends on the people. The question is whether on top of the operating company to be founded, whether a holding entity should be founded. Yes, it makes sense, because it is a taxation issue. Because if you exit later on, and then you have the exit proceeds in your for instance GmbH, and you can reinvest them, and it's a different taxation. It's then as well capital gains tax. And
So you do that on start when you start your UG?
the question was whether the setup with a holding GmbH or UG on top should be done right at the beginning or afterwards. From my mind, it should be done right at the beginning, because otherwise you have to transfer the shares. It is notary costs, and the problem is what's the remuneration for that, because at the very beginning it's nominal value, and later on, since you have different valuations, and at least the tax authorities will then have a look whether it's a gift and then gift taxed, or whether you put in, if it's like your personal holding company, you can put your country or your investment into the company, then it works, but then you can't use an UG, because with a UG you can only make cash incorporations. So if you put in the money in cash, you can't put in like 500 euros by way of two MacBooks or so. So the question was with regard to UG and GmbH, whether it is correct that by law you have to put in part of the profit for a capital increase in order to increase the share capital up to 25,000. So the normal stated capital of a GmbH. Yes, that's the law, but it is not necessary. In particular, in the beginning, you are not really making so many revenues that you can put a fourth to the side and then make capital increase. So it is possible, but it's not a must. There is the law. If you have the revenues and the profit, then you should put something aside. But in the very beginning, your profits will be maybe they will be big, but in general they are not that big. And then normally, like, capital increases are more done by normal capital increases that either the founding members or other outside third parties, investors, they do invest, and therefore you do a capital increase. The question was whether you can get your share capital you invested as a founder, whether you can get it back. My straight advice is not to, because you shouldn't do. That's the law, because otherwise there's some liability involved. So there shouldn't be any instances. The question was if you want to launch a website, whether you have to have the whole complete setup for your company and everything. No, you don't. You can launch a website, but then, like with a legal notice, you have to tell who you are, who launched the website, and then you appear there as a natural person, like an individual. And therefore, you will, if you violated any other IP rights, you will be personally liable. So that's about liability. You can do it, but then you have no kind of umbrella of limited liability with a UG or a GmbH. The question was again about the holding on top of the operating GmbH. It can be UG, it can be a GmbH. It doesn't matter. The further question is whether it has to work, so be active. It can be just a mere holding company. Like a lot of investors and like serial founders, they have their investment UG, and it's just for investment purposes. There's no really active other. The question is with regard to the holding company, whether there are any disadvantages. So to say, the disadvantage that you have to have another company, you have to do the annual accounts and tax returns and stuff. And I think probably in the beginning it's for some founders as well a matter of money, because then you have to put in another couple of €100 for founding this company, and the notarization costs, the registration costs, and so it adds up a little. But from my point of view, it makes sense to do it. Yes, the question was regarding to the question before, to the website. So if you start off with a website like an individual, whether the rights to the website and stuff then need to be transferred to the company. Yes, that's correct. So everything you started off, if you are a bunch of friends and you had a good idea, a business idea, and you already start off coding or developing, have some marketing ideas, a trademark and whatever, and you haven't still incorporated a company, then you might be a partnership where all this stuff is incorporated in a partnership. And at the latest, when an investor comes in, he asks, okay, so where are the rights to this figurative mark and to the website and whatever else IP rights there might have been created, and then you are normally asked to transfer these from either the partnership between you 2-3 founders or from one of the founders to the company.
So once again, actually, this implies some.
Yeah, in the beginning, if you start off like an individual with your website, you won't have such an agreement because you haven't got the company yet set up, but at a later point in time you will have a written agreement, and then we'll have to probably to involve a lawyer to draft that agreement, yes. So the question is, if you're working as a freelancer and you have a non-competition agreement or an agreement that all IP rights created during the work for this entity are transferred to the company, and later on you decide, yes, now it's time for me to start my own business, and you start off, and then you get a claim that you might have infringed those rights, IP rights, which you created for the other company. This is yes, a little bit difficult because it really depends on the clause, non-competition, and the IP right transfer clause, whether this is all covered. then it is the agreement and you are in breach of this agreement. But the question is also, is it exactly the same you created there, or is it a further development, or is it a variation? But this is very, very case specific, so it's hard to tell just in general. The question was whether Gewerbeanmeldung, so the registration with the public authorities that you are have started a business, not the commercial register, but the Gewerbeamt, whether you have to do it. In generally, yes. It's not anymore part of the foundation process. Like until close to 10 years ago, it was part of the foundation process that you had to show that you have the approval and you have already registered with the Gewerbeamt. Now it is assumed that you do so, but it will not slow down the registration process. Because when the electronic commercial register was introduced in Germany, they said, okay, we want to speed it up, but bureaucracy in Germany is slow, so we have to skip this one as being part of the foundation process. And then it's still an obligation if you are in such a business, and you have to apply for it or register it, but it's not slowing you down during foundation.
What kind of business should be registering
It starts off very small and it goes up very high. It's not New York rates, so I think there are lawyers charging as well 100 or 150, and others are charging up to 800. But for like in the very beginning, like since these are common things, you should approach the lawyer and say, okay, for whatever, drafting this in this contract, you do have a short meeting and say, okay, I need a contract for this. What would it cost? Can you give me an estimate? Lawyers are more hesitant to give you a cap because it's always hard, because in the end it develops in another way than you anticipated. So sometimes even maybe you can get a cap from a lawyer, but normally we're a little bit hesitant to do so. But at least go and ask for estimates, and then you can see, okay, is it worth engaging the lawyer for this, or is he overcharging here? And so the question is, what is important in choosing a lawyer, whether a PhD is important or more like the personal fit. I think this applies to both lawyers and notaries. First, ask your friends and colleagues, can you recommend someone who is knowledgeable in this field and who knows how to deal around and is quick in his mind and has language skills, and for sure it needs as well the personal fit, because if you can't get along with him, you are arguing with him instead of creating in short time the contracts and other documents you need. Yeah. So the question is, where you founded your company, you have a bank account, and you have got the stated capital in the UGs, let's say 1,000 euros, and you want to put more money into the bank account. This is the same when you do capital increases with investors, because you normally don't put the whole amount. If you say, okay, that's a very small round, only 100 or a couple of 100,000, you don't put the whole amount into the capital increase, because then it is fixed, and there is a certain statutory provision that you have to preserve the stated capital. So normally only a very small amount, a couple of €100 are the capital increase, and the rest is paid into the capital reserve, because the money which is paid into the capital reserve can be used and also used for other purposes, and you don't have to preserve it like the stated capital. So it's only in a matter of bookkeeping. It can be just simply paid into the company's account, but then it's not a contribution to the capital account, but a payment into the capital reserve for bookkeeping. You can. The question is whether you can. It makes sense to have 2 or even more accounts for the company. You can have a lot of accounts if you want to pay all the bank fees. You can do so. You definitely need one, and there are different companies who have 2 or 3, because some people think the fees are with that bank smaller or it gets quicker. Like normal corporates, they normally have 2 or 3 different bank accounts. But for a startup, I would say 1 is enough. Because you see your static capital anyway, you have to put it on a separate line in your annual accounts, and you have to take care that this money is not gone. But yeah, do you want to put it there and just leave it and not work with it? It's as well whether you have enough funds to do so. I'm not a tax advisor, so this is like the capital gains tax is about 25%, and if it's like income, it can end up to 40-50% in comparison. At least that is my understanding. The question was, is there a difference under German law about issued shares and authorized shares? We normally don't use the term issued shares, because if you found the company or do a capital increase, these are the normal shares, but there is as well a possibility to have authorized shares. So if you, for instance, for ESOP program, you can create approved, so authorized shares, and then use them over time. So the management is authorized by the shareholders meeting to issue shares and do a capital increase. So it does exist, but we don't use the term issued shares compared to UK or US law. Yes, but normally with like investors coming in, you don't have authorized share capital. You do invest like in just a plain capital increase. Yes. So it doesn't matter if it's a UG or a GmbH to be the holding company, because the UG always says it's a smaller sister, because it was like facilitating and as well to have a counterpart for a UK limited when it was introduced. Yeah.
Would you recommend freelancers?
The question was whether it is advisable for freelancers to have their own UG as a kind of umbrella. It really, again, it's a matter of the individual facts, because the question is whether as a freelancer you encounter a huge liability risk. If so, you might want to think about it. If it's for other purposes, I think the pros and cons, like what I said before, having to set up annual accounts and taxation is different. Whether this makes sense in your specific case.
You mentioned that when a corporation found the company, this would add a lot of...
The question was whether an investment vehicle from outside of Germany has the same benefits than probably under tax law as German entities. Yes, it's the same. So it doesn't matter if it's a Swiss corporation or a Austrian GmbH or a UK limited. The tax benefits are in general the same, because when they're taxed here, if there is additional tax in their country of origin, it depends, and this is also the question whether there are any double taxation treaties.
Okay, so the value only for the taxation, or so when...
No, it's not. The question was whether it is better to have this holding structure when an investor comes in. It's not a matter whether it's more attractive for an investor or not. It is just for your own taxation purposes, because the investor normally comes in with a legal entity anyway. Yeah.
Are there any other insurances you recommend for you?
The question was whether you need a legal insurance or so. To be honest, I have none, but some lawyers do even have legal insurance, not like the liability insurance for my work, but personally, I think for drafting you can't use it anyway. For some infringement maybe, but yeah, I don't think it's necessary, but it's in the end up to you. Good. Thank you.
You're not funny.